Please make welcome this morning Judge Gary Clary.
Thank you very much, man. Well, good morning to you. My name is Gary Clary, and I'm delighted to be here with you on such a momentous day. And when I say momentous day, when you consider the history of our country and the Constitution of the United States, 227 years ago, 39 very brave and courageous men put their name on the Constitution of the United States. And the very interesting thing about my career is for getting close to 40 years, I have been an advocate, a defender of the Constitution of the United States. I've been blessed in my life to have a lot of wonderful opportunities, and one of those was being a lawyer in this state. Had the great opportunity. You can leave those however you want them. If they can see the screen a little bit better with it off, it's not going to bother me. Then you can't see me. Okay. But I've had a great opportunity throughout my career to actually have a hands-on experience with the Constitution. And when I became a circuit judge, each and every day I dealt with constitutional issues. And it's always been a wonderful document that I've had the opportunity to live and breathe and to represent people who had issues that dealt directly with our Constitution, and then to actually interpret the Constitution and apply it in everyday life. As a member of the South Carolina Bar Association, and then when I was sworn in as a circuit judge, I raised my right hand and swore to preserve, protect, and defend the Constitution not only of this state, but also of the United States. And in preparing for today, there are a lot of things that you can talk about when you consider the Constitution. 227 years of history that we are talking about. And so what do I approach to discuss today with you? I know you're not lawyers. You're college students. You're probably thinking, what in the world am I listening to this guy for? But I hope that at the end of this day that you will have some better understanding of the topic that I've chosen, and it'll also pique your interest when you start thinking about constitutional issues, because you only have to go on the internet, turn on the news at night, read a newspaper to see something constitutional that's happening each and every day. So what I've decided that we'd talk about today is the subject of constitutional interpretation. Constitutional interpretation is always something that raises eyebrows in the legal world, because a lot of people, and what I'm about now, I'm kind of changing roles. I've gone from being a lawyer and a judge. Now I've gotten into the political system, running for the State House of Representatives here, representing this area. I won the Republican primary back in June, and now I'm in a general election coming up in November. A person's political beliefs are something that are twofold in my opinion. Number one, they're personal, but they're also public, because if you decide to step out and to get involved in politics, then you're going to let your beliefs be known. And so when I became a judge, I had to put my politics to the side, because I'm supposed to be unbiased, have no prejudice, and to make decisions in a vacuum where I'm considering the law or the Constitution and interpret that to the very best of my ability through the training and experience that I've had. We're going to look at two periods in the U.S. constitutional history, and it's pretty recent history. We're going to look at decisions that were made by two different courts. One called the Warren Court, named after Earl Warren, who was the Chief Justice of the United States from 1953 to 1969, a 10-year period. And then the Rehnquist Court. Chief Justice Rehnquist was the Chief Justice of that court from 1986 to 2005. So we're looking at about 30 years of history. If we tried to look at each and every Supreme Court and the Chief Justice that headed it up, I'd be here all semester. And I know Dr. Myers wouldn't want me to do that. But we're going to look at these two courts because both of them offer stark contrast to the way that we interpret the Constitution. You know, although judges, when they run for or offer for office, they don't have platforms. You know, in South Carolina, we have a system where our legislature elects our judges. And it's really improper for a member of the legislature to ask me my views on particular instances that would come before me. Because, once again, I'm supposed to be without bias and without prejudice. And if I start talking about the way that I interpret things, then I'm going to be influenced as a result of that. Because that legislator's political persuasion may be totally different from the way that I would interpret the law or the Constitution. Keep in mind, though, that judges do hold political ideas and beliefs. Most of them have been actively involved in politics throughout the course of their lives. You know, I've been involved in politics my entire adult life in some form or fashion. I worked in numerous campaigns, but when I became a judge, I became non-political. For that little over 10-year period that I served the state of South Carolina, I was not involved in politics, nor could I be. These beliefs, though, that you take to the bench with you certainly have an influence on your opinion in one way or another. And people strongly debate the roles of the court in politics and the roles that personal belief and political philosophy should have. So let's talk a little bit about judicial philosophy. Judicial philosophy is the way that a judge understands and interprets the law. Judicial philosophy is the way in which a judge understands and interprets the law. You know, after I'd been on the bench for a little while, lawyers knew and litigants knew what my judicial philosophy was. They knew that on the criminal side, that I would make the state solicitor, that's our prosecutor, jump through every hoop that he or she was supposed to ensure that that person received a fair trial. I made sure that it was done the right way. I was very demanding. I was very exacting. You know, I always told lawyers, and when I talk about lawyers, I'm talking about prosecutors as well as defense attorneys. You go to court, you come to court thousands of times in your career. The person that you're representing or prosecuting only has one day in court, one time in court normally. So you need to do it to the very best of your ability. Was I tough? Absolutely. And I don't apologize for that. Because the job that I had was too important not to be tough and demanding. Was I fair? I made every effort to be fair. That was my job, to be unbiased, to have no prejudice. So, with that backdrop, the judicial philosophy that I had is, after I made them jump through all those hoops, after I made them measure up to what I expected and the law demands, what happens if someone gets convicted? That's my role as the judge to sentence them. I had sole discretion. The legislature establishes sentences for various crimes. You know, murder carries up to life in prison, a minimum of 30 years now. But I had a wide range in there. Burglary, first degree, up to 30 years. And people knew that my judicial philosophy was that if someone got convicted, they're probably going to jail for a pretty long time, particularly depending on the crime. Now, the main types of judicial philosophies that we're going to talk about today are judicial activism versus a judicial restraint, loose construction versus strict construction, and then a living document. And when I talk about a living document, I'm talking about the Constitution versus original intent. You know, some judges develop a philosophy that's called activism. They use the bench. They use their role on the bench to enact social and political change. You're going to see when we talk about the Warren Court, it was very active. Very active. Other judges practice a philosophy of restraint, believing that judges must interpret the law very strictly rather than to seek to make news or new law. If you could pigeonhole me as a judge, when I'm interpreting the law, which is different from the Constitution in my mind, I was a very strict constructionist. I believe that the law that is passed by the legislature needs to be interpreted as well as it possibly can within the four corners of that document. I believe that it is my role, and it was my role as a circuit judge, that I look at the law as the legislature drafted it and enacted it and try to apply that to the situation that was before me. So I was a judge of restraint. The big difference, though, is when someone is interpreting the Constitution. That doesn't necessarily mean that you're going to be a strict constructionist, an originalist, interpreting the Constitution as it was 227 years ago. Now, there are judges, and I'll say this, all judges, regardless of their philosophies, develop their own routine or method of interpreting the Constitution and reading it. You know, as state circuit court judges, you're called upon to interpret the Constitution on a daily basis, particularly when you get into the criminal law area. Some judicial philosophies tend to coincide with their political views. You know, most strict constructionists, people that follow the Constitution to what they view as the letter of the law, are advocates of judicial restraint, but it doesn't always work that way. And then there are many advocates of judicial restraint who follow the doctrine of what we're going to talk about, that's original intent. These views don't always overlap, and as a result, these philosophies are not the same as what I would call a political ideology. Let's talk about the Warren Court, that 1953 to 1969, and let me give you a little bit of a synopsis of what they did. In 1969, Chief Justice Earl Warren, who was from California, appointed by Dwight Eisenhower when he was President of the United States. Dwight Eisenhower, as many of you will probably know, was a highly decorated five-star general, one of the real brain trust, or the brain trust of World War II. And he became a very popular president, and he named Earl Warren as the Chief Justice while he was president. When Earl Warren stepped down after presiding over the court for 16 years, it was a period that was marked by controversial decisions and very impassioned public debate. I remember as a child hearing my parents and others talk about Earl Warren, and it wasn't always a flattering discussion. Growing up here in South Carolina, a very conservative area, Earl Warren and his court were very liberal. Not the norm for what we have around here. There were heated conflicts over items such as desegregation, the case of Brown versus the Board of Education, which established integration as we know it in the United States of America. There was also a revolution over criminal rights in the United States. Everything from Miranda warnings to the exclusionary rule, and we're going to talk about some of those things. And over issues of religious freedom that were guaranteed in the first 16 words of the Bill of Rights, which are the first 10 amendments to the Constitution. Now, the Rehnquist Court issued a whole array of important First Amendment decisions involving both speech and religion. They also dealt with the Commerce Clause, a very esoteric part of our Constitution that deals with the way that we do business in the United States, racial quotas, and they even decided a presidential election in the case of Bush versus Gore. Now let's look at the different aspects of constitutional interpretation. And I hope you'll be able to see this. We're going to talk about judicial activism and judicial restraint. If you're a judicial activist, there is the belief that the court should overturn bad laws and create new policies. You know, that's that judge that gets involved and stirs things up. Where in judicial restraint, the courts must interpret the law and not legislate new policies. You know, you're not supposed to do certain things as a judge. Number one, make law from the bench. The only reason that you would do that is if the legislation was so poorly crafted that you have to interpret it yourself. And when you do that, you go back and look at the legislative history behind that law. You know, the legislative history is all the documents that you have available when that law was created or passed. There will be transcripts from hearings. There will be various papers written about it during the process of the drafting of the legislation. So with that understanding, you should know that when a judge starts interpreting the law and not legislating new policies, then he is practicing judicial restraint. Now, the Warren Court is a perfect example, as I mentioned earlier, of judicial activism. The Rehnquist Court, judicial restraint. And it's interesting the people that appoint these folks to the bench. You know, Dwight Eisenhower, a Republican, the Conservative Party, appointed someone like Earl Warren as the Chief Justice. William Rehnquist comes along and he's appointed by Ronald Reagan. That seems to fit. But you know, sometimes during the process of appointing members to the Supreme Court of the United States, their political views and beliefs are not made known to the person that is appointing them, and that's the President of the United States, and then they have to be confirmed by the U.S. Senate. And up until recent years, there was not this great hue and cry about really scrutinizing judges as they're being appointed to the Supreme Court. There's always been scrutiny, but I think the scrutiny now is so intents, I don't see how anyone ever gets confirmed. You know, when I became a circuit judge in this state, I went through a process where I had to go through the screening, the merit selection commission, and then I had to campaign for 20 weeks at the legislature to try to convince a majority of the 170 members of the South Carolina legislature that I was the best candidate. When someone is selected for the U.S. Supreme Court, their name is sent to the U.S. Senate, and they conduct hearings, and they go through the idea of trying to figure out, are they going to be an activist, or are they going to be restrained in their rulings? And when we look at judicial activism in that Warren Court, we're talking about civil rights, you know, Brown versus the Board of Education, which drastically changed the landscape of our society, which was a good thing. The rights of the accused. You know, we're talking about the right to remain silent, the right to have a lawyer, the right to a jury trial. All of those things that the Constitution spell out or speak to, but don't necessarily spell out. Keep in mind the Constitution was adopted in 1787, and we're applying it now 227 years later in a totally different society. Now, the Rehnquist Court limited the expansion of federal power. You know, and particularly in a state like South Carolina, we believe in states' rights. Most states do. Because we have the idea that we can run our state pretty well without federal interference. You know, all these things become issues in political campaigns. I find that out when I become a candidate. Certain things that happen. You know, out of a budget in South Carolina of about $7 billion a year, it's really about $27 billion because of all the federal money that comes into our state. So federal money, and some people regard it as federal intrusion. While we depend on that money, there are strings that are attached to it. So the politics of these activists tend to be liberal. Politics of these judges who practice this judicial restraint tend to be conservative. So judicial activism, judicial restraint. That activism, as you can read, really says that the court majority applies a personal or political ideology that goes beyond the intent of the legislation or the Constitution. They're injecting their 2 cents worth into it, and that influences the decision. And they use that to justify that decision. You know, there's this idea that when you become a judicial activist, that you've overstepped your bounds because you start legislating from the bench. You're in essence substituting your ideas for that of the legislature. And we have 3 distinct branches of government. So there's that violation of the separation of powers. Now, judicial restraint, once again, says that those judges or that judge have, in essence, agreed or acceded to the wishes of Congress by upholding the legislation, by adhering to the doctrine of stare decisis. It's a fancy word, meaning that you rely on precedent. You know, when I would make a decision at the state court level, I relied on stare decisis every day. What has been the rule of law? I'm not trying to deviate from that. I'm merely trying to continue it to make sure that we have good, consistent policies and procedures so that when you come into court, you have a good idea of what the ruling is going to be. Judicial restraint is commonly associated with the status quo. Now, we've talked about judicial activism, judicial restraint. There's another couple of terms, loose construction, strict construction, that really mean the same thing. We're talking about the same types of issues, but it's just a different way of expressing it. Loose construction. Courts should read the Constitution very broadly and should not limit themselves to what is explicitly stated. The strict construction should not reinterpret the Constitution. We're going to get into a little exercise in a few minutes where I'm going to ask you to apply these things. Once again, the Warren Court, loose construction, Rehnquist Court, strict construction. Loose construction, the exclusionary rule. The exclusionary rule is a part of the Bill of Rights that basically says that any evidence that's obtained during a search, if it's illegally obtained, is not admissible into court. You know, you have to have a search warrant, or it has to be in plain view of the officer making the arrest. Those are the kinds of things that you're looking for. Because without certain requirements that are protected under the Bill of Rights, your door can be kicked down, evidence can be obtained, and you can be sent to prison. Our forefathers had a great fear of that. The people who drafted the Constitution knew how things were in England. They wanted things to be different in this country. The right to a government-funded attorney. You know, that's not something that's so new. The idea that if you can't afford an attorney, that one will be appointed for you. As a circuit judge, I would go through a litany of interchanges with a defendant, you know, about statements that they had given, called the Miranda Rule, which tells them that, you know, they have the right to remain silent, that anything that they say can and will be used against them in a court of law, that they also have the right to a lawyer, and if they can't afford one, that one will be appointed for them. This is what the Warren Court focused on. Because if you don't have money to hire a lawyer, then you're out of luck when you go into court. That's the reason that they expanded their interpretation of the Constitution. Now, the Rehnquist Court, in their key decisions, restrictions on abortion, eliminating federal rules for state government, tending to be more conservative. So when we talk about this loose construction, this strict construction, under that loose construction theory, the federal government can take reasonable actions that the Constitution does not specifically forbid. Strict construction, once again, you favor the idea that the federal government should only do what the Constitution says that it can do. That's that very narrow, very strict reading of the Constitution or the law. Then we get to the final slide here that I have on these three different areas. We talk about the Constitution being that living document, and then also the original intent of that document. When we talk about a living document, we're saying that the Constitution has to expand, it has to grow, it has to adapt to new circumstances. You know, what we're dealing with here, the electronic age. You know, I could go get on the internet and it opens up a whole new area of the law. You see all the time how people are arrested because of things that they've been doing on the internet. Child pornography is one very big area. Now, the belief under the people who adhere to the original intent says that the court should interpret that Constitution as the framers intended, and it goes into restrictions on privacy rights. Once again, the living document people tend to be liberal, and the original intent folks tend to be conservative. So original intent, the idea that we always interpret that Constitution in the way that the framers intended. You know, what did those 39 men who got together and came up with this great idea, what did they believe that we needed to do? That means that the interpretation is going to be a matter of history. You know, if you go back into what I would call the constitutional intent, you're going to be looking at speeches that were made at the Constitutional Convention, maybe debates that they engaged in that were somehow reduced to writing. Arguments along this line will use that type of evidence to show what was meant to be used and interpreted. But that living Constitution kind of expands it, means that it's going to be interpreted in a way of today's society, today's morals. How does it apply to 21st century America? And once again, this idea that we're going to try to show what the common man wants and needs and how this decision is going to affect them. More humanism, I guess, would be the way to describe that. You know, I said when I was a child that there was a lot of talk about Earl Warren and how liberal he was. You could ride around the countryside and see signs like this. Save our republic. Impeach Earl Warren. I remember seeing these billboards as a child. It was a very, very divisive court. I'm sure that a lot of liberal thinkers probably wanted to put up signs, impeach, Rehnquist, save our republic. I never saw any of those. You know, this begs the question, where do you stand on these issues of interpretation? I'm going to throw out an example. The Second Amendment, the right to bear arms. Let's talk about, let me read exactly what the Bill of Rights says in this regard. Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. If you are a loose constructionist, tending to be on the liberal side, how do you interpret that? If you are a strict constructionist, how do you interpret that? You know, as a strict constructionist, it's pretty clear. 1787, they had muzzle-loaded guns. Single shots. You know, you fire that thing one time, then you got to think about packing everything in there before you pull the trigger again. Or that living document, things have changed. We have different types of weapons now. You know, these are the kinds of decisions that judges have to make each and every day, particularly appellate judges. You know, as a trial judge, which is what I was, I tried cases every day. Civil, criminal court. And probably in a 10-year period, I tried close to 2,000 cases. I'm trying to use stare decisis, that precedential law, to guide me through making decisions. And if there is a law regarding a firearm, I know what the Second Amendment says. You have the right to bear arms. But there are states, municipalities that will pass laws that try to, in essence, limit the Second Amendment. You know, when you have something that happens, such as Columbine, Sandy Hook, there's an immediate reaction to, we need to do something about guns in this country. Well, the Second Amendment says that we have the right to bear arms. But folks will use the idea a well-regulated militia being necessary to the security of a free state. The right of the people to bear arms shall not be infringed. That's been interpreted that you and I have the ability to own a gun or guns. Now, does that mean that you can have guns that have the capacity to fire over and over and over again? Under the living document, yes. Under the strict construction standpoint, maybe not. What do you feel about that? Don't all speak up at one time now. Yes, sir. Yeah, you know, it's a dilemma. The idea that you have the right to have a weapon is provided for in the Constitution. But to have the ability to, and I'm playing the devil's advocate here, to have a high-capacity magazine that can be interchanged, is that what the forefathers envisioned? Not on your life. I mean, they had no idea. They also had no idea that we were going to have the internet. They had no idea that we'd be riding around in vehicles. That certainly changes the way that things happen. You know, someone goes in to rob a bank, they're not walking down the street or getting on a horse, they're getting in a car. Things change. And I think that's what we're trying to say. Yes, ma'am. It's a balancing act, isn't it? Yeah, you know, listen, I have friends. I'm not a hunter myself. I do other things. I'm not a hunter. But I respect their right, number one, to have that weapon, that .30-06 or whatever it takes to bring down a deer, if that's what they want to do. But do they need something that shoots 30 times to do that? Yes.
What do you think the intent of the Founding Fathers was in guaranteeing the right to bear arms?
I think that is very clear, that our Founding Fathers knew what it was like in England when the government forbade them having arms. And they didn't want that happening here because they didn't know what direction this country was really going to take. You know, this is a fledgling operation. We're just getting started. And what they're trying to do is to ensure the problems that they had in England didn't follow them here. So this amendment was huge for them. And I think that because of that, we know that we have the right to bear arms. There's no question about it. Now, does that mean that you and I have to have one? No. That is our personal choice. And that's the beautiful thing about living in America. Yes, sir.
Follow up on Dr. Myer's question, to be more precise, I believe what the founding fathers wanted to do was to have our citizens have the ability to protect themselves against a tyrannical government, an imperial government. And while they might not have known what a bazooka was or a rocket-launched grenade, also the government back then, they had single-shot muskets as well.
Yes. Yeah, a well-regulated militia, and a militia is a group of people who band together or join together, being necessary to the security of a free state. This is a free country, and that's what they were trying to develop. But there was also the idea in the back of their head, we know how it was in England. We don't want that to happen, so we want people to be able to defend themselves and to defend our country. Let's talk about very quickly, what time are we in? 9:50? 9:50. Let's do this. Questions about anything. Because we've got about 3 minutes. And I don't want to get into anything on the exclusionary rule or the Fourth Amendment, which we talk about unreasonable searches and seizures and so forth, because that's a whole different day. Any questions about anything that we've talked about here today? I hope that this has been something that will maybe pique your interest when you see things that happen in our society and you understand that there is a constitutional issue or basis behind it. Because, hopefully I'm going to Columbia in January to enact laws that will be clear so that judges don't have to be judicial activists.
Judge Clary, we want to say thank you very much for taking the time and the effort to come out and speak with us today. We appreciate all that you've shared with us. And